Our next speaker, George Terwilliger, has served both in the Reagan and Bush administrations as United States Attorney and in the Department of Justice. He is a highly respected attorney here in Washington, D.C. He will speak to you about the criminalization of environmental liability. George.
Thank you, Bill. Good morning, and welcome to Washington. I hope that others have welcomed you to the city and that you've had some time to get around in this time of much political turmoil, which is wonderful for all kinds of businesses in Washington, from the media to the lobbyists, that you've had the opportunity to look around this city a little bit. I've been here a long time now, and yet I still find this to be an inspirational city, even when you're forced up close and personal to watch the sausage being made. So I hope you'll take the opportunity while you're here to enjoy a little bit of Washington and have an opportunity to reflect on what it means to our country. And I want to thank AEI and Brookings for inviting me to be here this morning. I think these topics are very important. I'm not an environmental lawyer per se. I represent companies who have problems with the government, so I deal with a lot of the things that the professor has been talking about on a regular basis, but among those are environmental violations. And I agree with sort of his fundamental premise that a lot of what we do today is counterintuitive to the objectives that we want to obtain. But much of that has been dictated by federal legislative initiative and the enforcement policy that engenders. And that's what I want to try to offer you just a little bit of perspective on, and then use the enforcement of environmental law as an example. Traditionally, at least up until the 20th century, the role of the federal government when it came to business regulation and the use of criminal law tools was to facilitate the flow of commerce, the doing of business, by protecting the means and instrumentalities of commerce. Today, we've strayed far away from that core purpose of the federal law and indeed of the federal government. Since around 1970, give or take a little, the federal government has actively used the criminal law to regulate business behavior, not merely to protect the means and instrumentalities of commerce. And you see this in a variety of industries and businesses, healthcare, financial reporting, and indeed the environment. And I'm going to focus on the criminalization of environmental law today simply because it provides an absolutely irresistible example of this phenomena. I want to say at the outset, though, in saying this, and having spent 15 years in the Justice Department, including at the line level and at the very top of the department, that I'm a strong believer that dishonest markets are not free markets, and that fraud in the marketplace damages not only consumers but businesses as well. You can see this when, as I am forced to do on a regular basis, you deal with trying to do business in ethically challenged parts of the world where dishonest markets indeed distort market forces completely. The purpose of the federal establishment at the founding when it came to criminal law was clearly to protect commerce and to protect the fledgling government from forces that might interfere with its functions. The Constitution, as we all know, grants Congress the power to regulate commerce and grants the federal government the power to punish certain kinds of behavior. And there's a big difference between regulating commerce and punishing commercial behavior because it exceeds certain standards. The government's power to punish went to things like treason, counterfeiting, piracy, felonies committed on the high seas, offenses against the law of nations. It said nothing about giving the government a role in policing commercial activity and using the criminal law to punish commercial activity that runs afoul of some legislative standard. So what the government was doing, and you can see this up through much of the 19th century, the government was protecting the means and instrumentalities of commerce. And as those grew into national enterprises, the government moved to protect them: the telegraph, the railroads, banks when they became national institutions, and indeed when interstate transportation improved to the degree, and interstate communication improved to the degree where the states were unable to effectively enforce criminal behavior that interfered with the means and instrumentalities of commerce. Thus, federal bank robbery became a crime. I'm sorry. Bank robbery became a federal crime early in the 20th century because bank robbers were moving from state to state, and there was an enforcement issue there. When markets became more nationalized, the federal government moved to protect those by protecting the integrity of the marketplace through securities regulation and so forth. The same is true of competition. When competition truly became a national phenomenon, when companies grew to be national in scope, the government stepped in to protect the competitive marketplace. Even later in the 20th century, when organized crime became such a potent force and tried to insidiously invade the commercial enterprise, Congress passed a very creative law called the Racketeer Influenced and Corrupt Organization Act, or RICO, to try to protect commerce from infiltration and pollution, really, if you will, by organized crime. In the 1970s, however, this changed because the federal establishment began to assert itself in a host of regulatory endeavors that had very laudatory objectives. To take the topic today, for example, we all want to breathe clean air and water. That's a very laudatory objective. The federal government stepped in to assert itself in setting some standards and practices and prohibitions for trying to achieve the objective of having clean air and water and handling toxic substances in a responsible manner. The same thing is true in health care, in the financial services industry in general, and most recently even in how corporations keep their books and report them to their shareholders and the investing public. As these regulations grew, however, so did the potential for the use of criminal sanctions to address transgressions of these regulatory standards. The ABA reported in 1998 that the growth of the federal criminal law has been exponential. From a report, the Federalization of Criminal Law, issued in 1998, quote, more than 40% of the federal criminal provisions enacted since the Civil War have been created since 1970. So the statistics back up this phenomena that I'm talking about. This is especially true in the environmental area. According to an article put out by the Cato Institute in 1995, there are only 25 environmental crimes prosecuted by the federal government before 1982. I don't know what that number is today, but it is certainly exponentially greater than 25. What this phenomena results in is the federal law making a crime out of what, but for a regulation, would otherwise be legitimate commercial activity. And these crimes are defined not by the legislature, and certainly not addressing issues of intent, but rather by regulators. Because what happens is Congress enacts a statute with broad regulatory objectives. It empowers an agency to implement regulations to accomplish those objectives and to require industry and business to meet standards, and then almost always provides criminal penalties as part of the enforcement mechanisms under those statutes. The result is that we have regulators, agency bureaucrats, and I don't use that term in a pejorative way, but the bureaucrats are defining the standards for criminal behavior. Environmental laws are clearly an example of this. I think, in fact, environmental laws provide a stark example of this phenomena.
The Resource Conservation and Recovery Act, or RCRA. Among the offense criminalized there are knowingly transporting waste to a facility that does not have the proper permit, knowingly disposing of waste without a permit or in violation of a permit, and knowingly treating or storing waste without a permit or in violation of law. And these are crimes of general intent. You simply have to, as you all know so well, be intending to do an act the law forbids. You don't have to know precisely that you are exceeding some permit by 1 or 2 parts per million, for example. This is true under CERCLA, under the Clean Water Act, and under the Clean Air Act as well. What the result is that otherwise legitimate commercial activity is rendered criminal by transgression of a regulatory standard. And if you step back and really think about this phenomena, it's very troubling as some of the things I think the professor has mentioned. It is not illegal to pollute per se in the United States if you take a common understanding of pollute. The government gives companies and people permission. They give them a paper that says you may introduce a foreign substance, even a toxic foreign substance, into the environment. But you may only do so under the following conditions and in the following limits. And if you exceed those, knowingly in most cases, that can be a felony. And the difference can be measured in parts per million. These regulations can be enormously, enormously complex and, in fact, dense. The result of that is that we are faced with a situation where complex regulations containing exacting standards about which experts can legitimately disagree become the stuff of criminal law. We also have judicial doctrines, such as the responsible corporate officer doctrine, that will make people personally responsible for violation of environmental laws because it was in the sphere of their business responsibility, even if they were not specifically aware of the conduct at issue. So where does this leave us? I think it leaves us in a perilous situation vis-a-vis the Constitution and the traditional role of federal criminal law. Because, as you recall, one of the bedrock standards of due process and one of the bedrock principles that has guided our use of criminal law is that we don't hold persons, whether they be legal persons or real persons, responsible for a criminal violation of law unless there is a standard that is clear and that people of reasonable intelligence can understand and conform their behavior, and unless they intentionally do something that the law forbids. These regulatory crimes, if you will, particularly in the environmental area, stand that standard on its head, and I think are unhealthy both for business and for our system of laws. Thanks very much.